Good afternoon, everybody. Welcome to our webinar today for the Florida Staffing Association. We're excited to present our next guest speaker to you today. So let me give you a little bit about Will Cottrell. He's an attorney who has spent his entire career representing businesses and individuals in business disputes, including disputes involving competition, employment law, and commercial litigation. For 6 consecutive years, he has been listed by Florida Super Lawyers as a rising star, which is a huge accomplishment. Will completed his undergrad studies in Mercer University. He received a master's degree in international economics from Florida State University. Go Noles. He received his law degree in magna cum laude from Florida State College of Law, graduating in the top 5% of his law class. After law school, Will served as a judicial clerk for the Honorable Hugh Lawson, United States District Court Judge for the Middle District of Georgia. Will is actively involved in a number of professional and community organizations. He is a former chair of the Employment Law Section of the Clearwater Bar Association. He is also a member of the Competition Torts Committee and Advertising Disputes and Litigation Committee of the American Bar Association section of Antitrust. He is also a huge supporter of our Florida Staffing Association. So I'm very excited to introduce and welcome Will Cottrell to our webinar today. Will?
Hi. Am I good to go?
You're good to go.
All right. Hopefully everyone can hear me okay. I appreciate the opportunity to be here. And this is, I believe, the first time since COVID where I am talking to a group, or at least I see a few faces on the screen. So it's nice to not be talking, as if I'm talking to myself, staring at a computer for the next hour. As he said earlier, my name is Will Cottrell. I'm based here in Tampa. I'm with a law firm that's based in Tampa, but we operate throughout Florida. And we practice exclusively in business litigation. Within that practice area, I would say well over half of what we do day in and day out deals with restrictive covenants. Taking a step back, obviously I don't know everyone's background who is attending. I know we have probably agency owners, we have people in the sales force, people on the recruiting side, and others. And within that group, I'm not, obviously agency owners may have some more understanding of restrictive covenants, what they are, how they work, the ins and outs, as opposed to non-agency owners or non-management. So I'm not going to make any assumptions about y'all's knowledge here. And so just, for those who already understand some of the concepts that I talk about, it'll just serve as, a time to brush up on what you already know. I encourage everyone to ask questions during the seminar. I realize there's apparently a lot of participants who are going to be a part of this, over 50 or 60 potentially. If we start to have too many questions, I'll address that then. But most of these seminars tend to be of most benefit for participants if they can ask questions as they arise during the seminar itself, and I'm glad to address those, and I encourage those questions. Finally, for all seminars I give, I like reminding people that, yes, we're here to learn something new, if it was in person, to be entertained and socialize, but that I hope you can at least take, at least, 1 or 2 things away that you can implement for your company to help improve its policies and procedures, or to help with certain disputes you may be having, just something that you take away from this to actually implement to improve your company, as opposed to just kind of an hour of CLEs, continuing education or something like that. Today's topic is non-compete agreements in the context of the staffing space. I refer generically to the term non-compete agreements, and that's if you're talking to another attorney, or if I wouldn't refer to non-compete generically, but for most people who aren't attorneys, a non-compete is what they call anything that includes kind of a non-solicit or a non-compete provision. So being technical about it, and I refer to a restrictive covenant, and you'll hear that term a lot. I'll use that and non-compete interchangeably. Just know that unless I specify otherwise, I'm referring to both non-compete provisions, saying, hey, you can't compete in a certain geography, something like that. And that's distinguishable from a non-solicit provision, saying, hey, you're not going to solicit our clients or prospects or something like that. Okay, but I refer to them kind of collectively as either non-competes or restrictive covenants. We will also cover some of the, in addition to brief recap restrictive covenants, I'll also cover some key provisions that I think are often missing inside of these restrictive covenant provisions that employers have that should always be in there. And frankly, I'm surprised when I don't see some of these. And then we'll get a little bit into the weeds on strategies for enforcing restrictive covenants as well as defending. Even so I put non-poaching agreements on here. We're actually not going to get into that today. That was I speak on this sometimes for in-house counsel, corporate counsel, because they deal with this more often. But know that if you are contemplating or have an agreement with another company wherein you agree not to go after each other's clients or each other's employees, something of that nature, that should immediately be a red flag to speak with counsel, as there are a lot of landmines in that area that get into some pretty hot water real fast with the government if you're not careful, okay? Also, just want to clarify that this presentation is given for the context of employers and employees or independent contractors. It is not in the context of a sell of business. So for agency owners, you're familiar with this. A lot of times they'll sell the company and you may have a non-compete provision in there saying that you're not going to, the other company you bought out is not going to start up a new company. That's a different situation, and there are some special, unique rules for that. We're not going to go into it, but if that comes up for you, feel free to reach out to me. All right, so this one is a, I say tongue-in-cheek, this sophisticated chart you're looking at is actually something I drew up on a napkin before I gave this similar presentation for the first time about a decade ago, just to help, give myself a roadmap, when explaining when it's a good idea to have restrictive covenants for an employer. Okay, and of course, the surprise, the answer is usually it's always a good idea. Okay, so starting off on the right side, maybe you don't even have any employees or staff. Well, you still may need something with vendors. Okay, so maybe you're someone who uses another company downstream to help fill placements for recruits that you have. Okay, you'd obviously want some type of agreement with them, even so you yourself may not have any employees or contractors. But for the normal situation where you have employees, if they have access to confidential information or substantial customer relationships that they have formed, so that they're kind of the face of the company, anything that they could use to their advantage against you if they were to leave and go start their own company or to go to a competitor, that's a situation where it would warrant having a restrictive covenant. Whether that restrictive covenant is simply a non-disclosure and perhaps a non-solicit, versus also adding a non-compete is a different conversation. But the point is, you want something in place. Now, I'll add that I've run into situations with employers who are just philosophically opposed to having restrictive covenants for their employees or contractors. And I'll say this, politics aside, that they tend to regret that decision once one of their former employees leaves and sets up shop and starts successfully taking their clients. All the philosophical leanings go out the door, and they wish they had an agreement to do something to help deter them from taking more of those clients. And on the opposite end, maybe you're someone, and there's employers like this too. I'm not advocating it. There's employers that have these for virtually all employees, and they have non-competes, non-solicits and non-competes that are, in my mind, on their face pretty overbroad, but they do that for deterrent reasons. Okay, in other words, it's questionable whether the agreement is enforceable, much less to the full extent that they provide but they just are hoping that by the mere fact that the employee has signed a non-compete or non-solicit, it makes it less likely in the first place they'll go out and compete. Okay. Now, with that said, if you fall into the category where, hey, our employees, for example, you may have employees, and hopefully don't, but maybe you have some that are not management and they're not in a sales role. Well, that right there tells you it's going to be tough to, it's going to be an uphill battle making arguments of why a judge should enforce a non-solicit or a non-compete against an employee, a rank and file employee who wasn't management and wasn't in sales, meaning they didn't have relationships with the customers. They weren't in a position to really look at or use confidential information while they were there, much less use it to their advantage when they leave. So if you want to have them sign something like that, where everyone's signing something, okay, just be careful that you don't drink your own Kool-Aid and believe that this agreement is going to be enforceable regardless of what type of employee you have, and go full speed ahead towards a lawsuit. If I would recommend, whether the employee, frankly, whether it is a rank and file employee or someone who is in management or who has who is outward facing, dealing with the clients, that you certainly speak with an attorney before sending a cease and desist letter, much less rubber stamping litigation. So I get no less than literally 3 or 4 phone calls a week, both from an employer or an employee asking, hey, is this agreement enforceable? And if it was up to them, they would just hand me the document. I would look it over, and in 5 minutes and give them an answer. That's just not how it works. The answer to whether the agreement is enforceable, A, at all, or B, to the extent it is enforceable, meaning how broad, is this non-compete overbroad, or is this non-solicit overbroad? It depends on several factors, such as the state that you're in, the language in the agreement itself, and most important, the facts or circumstances that relate to that employee or contractor, as compared to, what it is they're wanting to do or where they're going. Okay. So the details, always matter in these cases, not just of the agreement itself, but what that person did for the company. So for example, whenever I have someone call me up and they want me to give them advice, I always tell them, send me 2 things. Send me a copy of the agreement, and I need the background information on what you or this employee does for the company, what's their title, what's their job duties. In other words, if your company makes widgets and you were in charge of selling widgets and just green widgets and just to these 2 counties, tell me that, and then let me know where is it that you or they went, what kind of widgets or what color widgets are they selling now, and which counties are they in. We have to compare apples to apples. Okay. Now also add that even if you have an agreement that is enforceable on its face and the facts would seem to justify having sufficient reason, and we'll get into sufficient reason to support a restrictive covenant in court. Oftentimes judges, and bear in mind, judges are not computers, they're human beings, okay? They want more than simply checking the legal boxes that something is enforceable. They want to see evidence of bad acts, something that just instinctively smells bad of what this individual has done. So for example, what we're always looking for is, did the employee email themselves a lot of stuff on the way out the door? The individual, have you received emails from customers showing the email where they reached out to them, to the client, and tried to get them after they left? That kind of stuff just is a smoking gun, and it looks bad for the employee. Okay. So we're trying to find evidence of things like that before getting in front of a judge. Again, it could still be enforceable even if you don't find, the actual documentation, that shows their bad acts, but it certainly helps. All right, so and this is kind of the restrictive covenants 101, if you will. What is the bare minimum that is needed to enforce a non-compete or a non-solicit or even a non-disclosure for that matter, okay? It has to be in writing. It has to be signed by the person against whom it's being enforced. Doesn't matter if the employer signs it, okay, as long as the employer contractor signed it. And it has to be supported by one or more substantial business interests. So oftentimes you'll be talking with an attorney about enforcing one of these agreements, and they'll say, okay, well, let's talk about your, what legitimate business interests you had, in this provision. That's a term of art, and it's referring to this specific part of the Florida non-compete statute, okay? And so you have to support one of these agreements, a trade secret or valuable confidential information, substantial relationships with prospects or customers, customer goodwill associated with things such as trademark, trade name, geographic location, or marketing area, or extraordinary training. So let's give some examples. So you may have and I realize this is not y'all's industry, but you may have a physician who works for a physician group or a dentist as part of a dentist group. They put a lot of money into marketing to a certain area because they know most of their clients are going to be driving within that 5 to 10 mile radius of their location. And so even if that doctor was kind of working in a silo such that they didn't have info to confidential information, which is unlikely, if they didn't have substantial relationships with customers, which could be depending on the type of medical practice, maybe they don't see clients more than once or patients more than once, a court should still enforce it if the doctor's group, or in this case, the staffing agency, can show that they put a lot of time and money into marketing into a certain area, okay? That's usually not quite as relevant in staffing because most things are done through meeting face-to-face and through internet and phone call. It's less about Google AdWords to a certain geographic region, but that's not always the case for staffing agencies. And just to be clear, again, it's not unlawful to have employees sign a restrictive covenant if you're unsure if it's going to be enforceable. They can sign it, something criminal about it. Just understand that when you go to enforce it, it has to be enforceable under the Florida statute, and that includes demonstrating that you have legitimate business interest. And by the way, going back to my example earlier, if you have, say, a receptionist, okay, and again, the odds of y'all having the receptionist sign a non-compete or non-solicit sounds ridiculous, but then again, Jimmy John's had people, the people making subs sign non-solicits or non-competes, and that made the news. It was so ridiculous, okay? So if you were to do something like that, just understand that it's not likely going to be enforceable against that receptionist. Again, that's an extreme example. There's other examples that aren't quite as extreme. And the reason why is because someone like that, they're not going to have relationships with specific prospects, either on the recruiting side or the sales side. They're not going to have access to the secret sauce, the trade secrets. Why do they need access to it? And they're also not going to have extraordinary training. So again, it's just, you got to be able to check some of these boxes, or at least one of these boxes, to enforce it. All right, so now let's actually get some examples here. Just out of curiosity, I'm asking the moderators: are people able to just chime in and speak without me having to press a button?
Yes, we just ask them to raise their hands, and we'll unmute them. That way, not everybody's talking at once.
All right. Well, I'll see if any brave souls want to jump here and answer any of these hypos. Usually, someone will. So let's go to this first example, just to help kind of flesh out, a lot of the law that we just covered. So in Florida, an employer tells an individual that hiring is contingent on signing a restrictive covenant. So you want to hire someone to be a recruiter or on the sales side. The individual is hired, but the employer neglects to actually get their signature prior to the start date. Happens all the time. Okay. So 3 months later, after the start date, okay, usually people catch this a week later, 2 weeks later, but let's just make this extreme example and say it's 3 months later, okay? And an individual signs it. So now the staffing agency, they don't provide any additional pay in connection with that signature that was obtained 3 months in, and we're in Florida. Is the restrictive covenant, let's say it's got a non-compete, non-solicit, and it doesn't really matter, Is that going to be enforceable? Anyone feeling confident enough to throw an answer into the ring? All right, well, at some point I'll get y'all talking.
How about, I've got a guess.
There we go.
How about no, because there's no, I just had it. There's no
I think you're looking for that legal term, consideration.
consideration. Thank you.
There you go. Well, if you were in a lot of states, you would be right, okay? Texas is that way. California is that way. I believe DC recently passed a law that's like that, and there's probably a half dozen other states that would agree with that. Here in Florida, and probably a little over half of the other states, it would still be enforceable. And the legal justification is that continuing to work there is the consideration. So in other words, if you don't want to sign this agreement, you don't have to stop working here. You won't be subject to it. Okay. Or if you keep working here, that is the sufficient consideration, if you will, for it. Okay. Now with that said, that just because it's legal doesn't mean it's right. It also doesn't mean the employee is going to be furious about it. And to be clear, it's one thing if the recruiter or salesperson you brought on, you gave full disclosure that they were going to be needing to sign something like this. But if you didn't tell them, and 3 months in or 6 months in, you then hand them things to sign and say, hey, you have until the end of the day or end of the week to sign it. Hey, you got the legal right to do so, but you're going to catch some heat at a minimum from that employee over it. Just appreciate that. If you're a prospective, if you're looking at a potential new employer, and you're going to accept the job offer based off the terms they've told you, and they did not inform you about a non-compete you may have to sign, and your current employer doesn't have one, then that's a material term. That's a pretty big thing to sign up for, especially if you're not already subject to one. And so, I always urge employers to, just let them know up front about it and have them signing it as part of the onboarding process, ideally before their first day, but certainly in the first week or two. Okay.
Well, we have a question. From Julie Anderson. We have remote team members sign our RC employee agreements who work in states outside of Florida headquarters. Which state laws apply if RC is broken? You may be covering this later.
Yeah, so I will be covering it later, but I'll address it now. And as always, you'll get from an attorney, it depends, okay? It depends specifically on whether your agreement has a choice of law and venue provision, okay? So let's say you're in Florida and you have a national footprint. Hopefully your corporate counsel was wise enough to include a provision that says the choice of law is Florida for any disputes over this, and that venue is going to be in Florida as well. That way, regardless of where they are at, they could be in North Dakota. You can still sue them here. Generally speaking, there's some exceptions to that, okay? But I won't get too much in the weeds. Generally speaking, you could sue them here in Florida, and Florida law would apply. And even if you couldn't sue them here, and they had to be sued in North Dakota, okay? And if you had a Florida choice of law provision, Florida law is still going to apply. Now it gets, that's the general answer, okay? It does get a little trickier, and that there's some states who say that, let's say we're North Dakota. I don't know North Dakota's law on this, but just run with it with me, okay? You say you're in North Dakota, and you have to file suit there for whatever reason, but you still have a choice of law provision for Florida. It's possible North Dakota law could say, you have to pass muster under both Florida law and North Dakota law, okay? And if North Dakota law says that this thing, you had to give them additional consideration for it to be enforceable, then you probably would have a problem. So unfortunately, there's no silver bullet, if you will, to solve that problem. but you can certainly short up with a choice of law and a venue provision and some other things related to that I won't get into, but like your corporate counsel would understand what I'm talking about. But so there are things you can do to help mitigate that risk. But depending on how far sprung your employees are, there's just some things that are in control if they're in certain states. All right, so I've already answered this one. So David would be right if it was California law. Okay, they do require that the employee receive additional compensation for the agreement to be enforceable if they'd already started. Okay, what that compensation is, I don't recall offhand. I could just Google it real fast or ask a California attorney. But there's several other states like California. All right, so here's another one to help flesh this out. And this is a good one. A sales employee has a restrictive covenant. So you got a person on your sales team. So he's outward facing, trying to bring in company clients to partner with the recruits. Okay. After 3 months, she leaves for a competitor and solicits the same clients. After, at a hearing, when I say a hearing, I'm referring to a injunction hearing. Okay. So you're before the judge, Your Honor, we want you to shut this person down now, issue an order saying they cannot continue to solicit our clients. Okay. At the hearing, the client testifies that they make purchase decisions based off cost and availability, and not, who they're working with. Okay. But on the other hand, the company demonstrates, the staffing agency demonstrates that the sales employee did in fact have contact with those clients while they were an employee. Is the court likely to issue an injunction? And this one, so you're not thrown off, I'll give you a hint. The answer deals with the fact that this was 3 months that they were there. Did anyone connect the dots on why this one may or may not work out in terms of getting an injunction? All right, fair enough. This one is a trickier one. The answer is, and this is actually based off of a real case, the court denied the injunction. The reason is, and I'll go back to the reasons so you can see it, you have to have one or more legitimate business interests. Well, in this case, the court looked at prong number, the second one, substantial relationships with specific prospects and existing customers. And the judge was basically says, hold up here. You're trying to tell me that the reason I should enforce this non-solicit is because this former sales employee of yours had substantial relationships with clients. How substantial could it be when they're only there 3 months? I just don't buy it. I don't think they're the face of your company, such that someone would be willing to leave to go with them after only 3 months. Okay. Now, to be fair, that was that specific case. Could there be scenarios where someone is only there 3 months, but let's say they only deal with 2 or 3 big clients and they interact with them every single day? That could very well lead to a different result. Okay. All right. So we've talked about, what an employer needs to have to enforce one of these agreements. It has to be signed in writing. You have to have legitimate business interest. We've got that. And now let's talk about limits to these agreements. And again, most of y'all know that you've heard the concept of a non-compete or non-solicit being overbroad. Okay, well, that can be overbroad in a few respects, both geographically and in temporal scope. Okay, first off, as a stepping back, big picture, and I see a lot of employers who miss this, including those in the staffing industry. If they're if you have to choose between a non-solicit and a non-compete, you want the non-solicit. Okay. If you're going to have a non-compete, also have a non-solicit. What you don't want to do is have just a non-compete with no non-solicit. And there's 2 reasons for that. One, judges are much more likely to enforce non-solicits than they are non-competes, because non-solicits, the business interest you have in that speaks for itself. We have an interest in them not going after the same clients with whom they were building relationships on our behalf. Okay. A non-compete it's a bit more, I won't say draconian, but it certainly packs more of a punch in that you're potentially keeping someone out of the industry altogether, or at a minimum requiring them to move from where they live to stay in the industry. And a judge recognizes that has a much more or a much more stronger effect on the employee or contractor. And the second is you have a situation where, what if you have just a non-compete, and let's say it's just for certain counties or for the state of Florida, and this individual over time started dealing with the clients who are outside of those counties or outside of the state of Florida, and so when they leave, you know what? They're not competing in Florida, but they're going after clients that are outside of Florida or outside those counties, which would be perfectly legal under the non-compete provision, and there's nothing you can do about it because you don't have a non-solicit, okay? Or it'll certainly make it much harder for you to do something about it, okay? Now, in terms of the scope of, what is reasonable for, I get this question a lot, well, what is reasonable in terms of geographic scope? Honestly, you don't even necessarily have to. I usually recommend two things. One, include the counties or states that you actually do business in, and then add a catch-all in any other geographic, area in which the salesperson or recruiter actually does business on behalf of the company. Okay, and more often than not, a court will enforce a non-compete that has legitimate business interest, so long as it's only covering the geographic territory in which the salesperson or recruiter is actually doing their work. Okay, I mean, as a war story, this one was a few years ago. This actually wasn't in the staffing industry. It was in, we get some really niche industries who come to us, but this one was for collections for unpaid parking tickets. Okay, that there is a whole industry out there of companies who all they do are work with local governments to collect on these unpaid parking tickets. This is one of those things. And our client at the time had a non-compete that said it was all of the entire U.S. They had no non-solicit, which was a very unfortunate, given the person they're trying to enforce against was a sales employee. So we knew, and the other side knew this too, if we go in front of a judge, the judge is likely going to say, okay, well, let's look at where this individual actually did business, okay? Not just state by state, but county by county. I'm not going to keep this salesperson out of all of Florida if they only did business in Hillsborough County. That seems overbroad to me. There's a legitimate business interest for that. So we went to mediation and had a literally 12-hour-long mediation where we, basically fought back and forth all day over what counties in the U.S. this person actually did business for. And the ones we could agree on ultimately, those are the ones that, we had a stipulated agreement, a settlement that they would stay out of those counties. Okay, but that could have been avoided had we just had a non-solicit or a non-compete that wasn't quite as broad. Okay. Any questions on the scope of enforceability? I usually have questions on there. Any questions before we move on to kind of a different subject matter?
I have a question. What happens when a company's dissolved? Does that negate the non-compete, non-disclosure agreement?
This is one of the rare times you'll get a direct answer. Yes. Yes.
Yay! Okay.
And the reason being, they are no longer competitive. Okay, so in fact, the Florida statute, and again, taking a step back here, the whole purpose of Florida's restrictive covenant statutes is to prevent unfair competition. Well, how is it unfair competition if they're not competing with you at all because you're out of business? Okay, so and built into the Florida statute is a provision that actually says, a defense to a non-compete or non-solicit restrictive covenant in general, okay, is that the company trying to enforce it is no longer in the same line of business or no longer in the same geographic territory, with the caveat that if the person trying to enforce it is no longer in that line of business, no longer selling that service or product, no longer in that geographic territory, is because the person suing took that line of business or took that geographic territory from them, okay? But if the company voluntarily stopped doing business in Florida or voluntarily stopped doing certain types of recruiting services, then it'd be fair game for that person to go after them. And getting into the weeds on this, and I've dealt with with some lawsuits that are very contentious over the subject matter, that gets down to the granular level of specific clients. Okay, so maybe you have, I'm just making this up, Publix as a client, or some other large company like that where you're placing a lot of people. If you as a company decided to, for whatever reason, get out of, you're making the choice to no longer have Publix as a client, okay? And that was a company-wide, a company decision, and it had nothing to do with, some individual leaving and taking Publix. And then that person later leaves and decides, well, I'm gonna start my own company, and I'm gonna go, and I have a non-compete, but I'm outside that area. I don't have a non-solicit, or even if I have a non-solicit, they may have a valid defense for going after Publix because Publix is no longer some of that company is using as a client. So how is it unfair for that former employee to go after Publix? Okay.
Thank you.
Well, I have a question, if you don't mind.
Sure.
In the situation where specifically non-compete is in a restrictive covenant that won't go to another competitor, if an employer, for whatever reason, makes an exception, knows about an employee that goes to a competitor, turns their head on the matter, doesn't say anything, does that now have ramifications for future enforcement, do you think?
Yep. 99 times out of 100, no. An employer has a right to selectively enforce these agreements. Employees don't like hearing that. I regularly have some rainmaker call us up and say, hey, I got this nasty gram from my prior employer. This is bogus. I know of several of the people who left and they didn't enforce it. I'm like, yeah, but I mean, you're the golden goose, So it's understandable they're going to come after you. The other ones, for whatever reason, they just didn't think were worth it to go after, and they have the right to selectively enforce that. Now, in theory, a caveat, which I've never seen and happen in practice, is if they were to only go after a certain person for a reason that was unlawful. In other words, it was that person, they did it based off a protected category. Think employment law all of a sudden, okay? So that person had, because of their religious beliefs or the color of their skin, okay, something like that. But it defies, reason to think that an employer would do something like that in that context. But in theory, if they did, that would be a basis for defending it, but I've never seen it. Good question, though. All right. So earlier when I first started, I was saying that I regularly see agreements that are missing boilerplate provisions that really, really, really should be in a staffing agency's, in any company's covenant agreement. And that applies regardless of whether it is just a non-disclosure, but especially if it has a non-solicit or a non-compete, okay? Because again, judges they understand a non-disclosure, okay? That they get the reason for it. It doesn't seem unfair for an employee to be subject to a non-disclosure. But when you start trying to prevent competition, that's where a judge is going to start listening a little closer to other arguments, including creative arguments, okay? So I'm not going to go into all of these provisions because some of them are self-explanatory, and I would encourage you just to look at your company's agreement if you're in a management position, in a position where you could have influence on revamping these. And most of them, but not all, will have a choice of venue provision. Most will have non-disclosure provisions. Most, but I would say 2 out of 10 don't have a successors or assigns provision. What I mean by that is, if you're a company who may get gobbled up by another company, okay, merge with someone or an acquisition, your agreement will no longer be enforceable, the restrictive covenant won't, unless you had a provision that explicitly states that the new company, the successor or assignee, okay, could enforce it. But some companies will do, at the very top, they'll say, staffing company, including its successors or assigns, as well as, John Doe, agree to the following. That's not going to cut it. Okay, you need an actual provision that says that the individual understands and agrees that this agreement is assignable to a successor, okay, or a subsequent employer who may purchase the company. Okay. Tolling, I wouldn't worry about that, but that basically says that if someone, I'm not about getting into it too much, but do make sure you have it in the agreement. It basically means that if someone were to breach the agreement and you went and enforced it in court, the judge could tack on more time of the agreement to make sure you got the full benefit of your bargain, the full 12 months, 24 months, whatever it was. This next one, change of title or position. I actually started adding this to agreements about a decade ago when I was a younger attorney, and I was working on this. I was trying to enforce a restrictive covenant agreement and non-compete, along with the senior partner at the time. The attorney defending it, came up with a really creative argument that, hey, this agreement says that it applies to John Doe. John Doe, who was hired by ABC Company as a sales rep, and then it went on to state the rest of the agreement. Well, over time, that individual had changed positions, became a manager, and his job title changed as well. And one of his defenses is, Your Honor, look, the face of the agreement says it applies to him as a sales rep. He stopped being a sales rep 3 years ago. So those 12-month and 24-month long restrictions, those have long passed. And, the reality is you can flip a coin, I think, on whether a judge is going to buy that argument. But in that particular case, the judge was sympathetic and bought the argument and denied an injunction, as that was our loss for our client. Okay. And so since then, I just started adding in and adding this provision saying that the employee, the individual acknowledges and agrees that even if he changes position or job title, okay, it's not going to affect the enforceability of the agreement. I'd also have a provision saying that you, the employer, can have the right to disclose the agreement and the fact this individual worked for you to that individual's subsequent employer. Okay. Believe it or not, you don't always have the right to reach out to someone's new employer and say, hey, they used to work for me. Here's their agreement they had. I think it's a problem. I think you should fire them. Well, what if you're dead wrong in the sense that the agreement, they weren't violating it, okay? But the employer just gets cold feet because you're even threatening them and they throw the person overboard. Well, that former employee can now sue you for tortious interference, okay? And they would in theory have a good claim. And you may think, what person would, well, first off, if that person actually had funds to fight, they would probably consider doing it. And there's some attorneys out there, believe it or not, if it was a black and white enough case, they would consider taking that on contingency. So the way to get around that, or the best way to mitigate against that concerns, but is having a provision there saying that individual acknowledges and agrees that you have the right to do this. Okay. Now, again, I won't go through the rest because of time, but if you have any questions on whether your agreement is missing certain provisions, whatever it may be, just let us know. We're glad to talk to you about it. All right, so now we're getting into the weeds on strategies for enforcing and defending against agreements. What time is it, just so I know? How much time we have left?
It's 2:45. You got about 15 minutes to include additional questions.
All right, we're on pace. So first off, as a matter of practice, I would, if you have a classification of employees, whether it be all your sales rep, all your recruiters, which usually both in this industry, have a non-compete and or non-solicit, I would sincerely recommend that you get in the practice of sending them a standard letter that you provide during the offboarding process. It's a matter of routine, just reminding them that they had this agreement and provide them a copy. Okay. That doesn't mean they violated it. It just puts them on notice. Okay. You'll be shocked how many people have forgotten they signed something or they don't have a copy of it. And their interpretation of what was in there is different from what's actually in there. Okay. So simply providing it to them can oftentimes avoid a potential dispute. Okay. if you decide that, or if you learn of someone who is potentially breaching an agreement, before you run off and send a nastygram, okay, I would, make sure that it's enforceable on its face, meaning you have a copy of the agreement and it's signed. Again, shockingly often, companies will come to us and they have agreements for some people who are doing bad deeds and not others. Okay, there's nothing we can do about the people who don't have a copy of the, with whom the company doesn't have a copy of the agreement still. Okay, or they can't find the signed version. Just can't enforce it. Okay. Also, I would make sure that individual, I would talk to an attorney to make sure that before you send a cease and desist letter, to make sure you haven't done any obvious employment law violations. The last thing you want to do is send a nastygram. That person goes and speaks to an attorney like me or someone else. They vet the whole situation and realize, oh, well, yeah, you're also owed 50 grand in commissions. So yeah, we'll gladly take this on. And actually 50 grand is kind of low, but we also have cases that are much more than that. Or maybe it's someone who, you paid as a salaried employee and it turns out you didn't know it, but they actually should have been receiving overtime. You just incorrectly assumed they were exempt from the FLSA overtime provisions because, oh, they're in sales and I pay them a salary, therefore we don't owe them overtime. By the way, that's a wrong analysis, okay? That's a different conversation for a different seminar, but we've had multiple instances of people coming to us and it turns out they were misclassified and we were like, great, we turn around and file a class action, okay? And I tell you, the employer, certainly behind closed doors, were kicking themselves for ever sending the nastygram in the first place. So just do your due diligence to make sure it doesn't backfire if you're going to send something. And also, as a small, because it happens all the time, it's usually smaller companies that do this. Don't withhold their last paycheck until you get property back. You legally can't do that. Okay. So again, I'm just trying to save you the trouble of doing things that will prevent you from enforcing the agreement at a minimum and potentially cause you more liability. Finally, you can do your own due diligence and will work with an attorney, but look for a smoking gun. If you think someone is breaching the agreement, go look for evidence. Either you or a forensics team, there's companies who do this, but you can do it too. Go look at their emails. See if they sent themselves anything in the last 60 days that looks suspicious. If a week before leaving or the day before they gave notice, the day they gave notice, you see where they email themselves the client list that has all the names and, history of who was placed there and the contact information. I mean, that's a slam dunk case, okay? That's also misappropriation of trade secrets. Maybe you'll look at their social media and realize, where they're at, just to confirm where they're at. Maybe you'll see online that they've set up a new company. That's in the address is within the same area as the non-compete that they're not supposed to be at. And I know and this is usually y'all wouldn't think of this, and I will look for it when it comes to me, but we even look to see if their spouse set up a company. It's shocking how many times someone goes out their own and starts a company, they know it may be a potential problem with the non-compete. So what do? They have their spouse set up the company under their name, which is ludicrous. Now they've gotten their wife or husband into a lawsuit, not just them. Them not setting it up doesn't screen them from liability at all. Okay, but those are things that to look for. So strategies for enforcement. Okay, so you've done your due diligence. You decide you want to go forward with this. Generally speaking, not always. I recommend sending a cease and desist letter. Putting them on notice of their obligations, reminding them, provide a copy of the agreement, let them know that, hey, we believe you're violating it. Here's the reasons why. Send us, confirm that you're going to stop doing these things. If you don't confirm, we'll view it as evidence that you are actually doing bad things. Okay, just put them on notice. If they don't respond, if I'm representing someone on the defense side, I always respond. If you don't respond, people just assume you are doing bad things. Okay. But if they don't respond, or if they just otherwise don't stop doing what you have a problem with them doing, would be soliciting your customers or working within the geographic territory of a non-compete, you can't sit on your hands. Okay. Under Florida law in most states, you have to act quickly, usually at most in a few months. So if you learned in this month that someone left and you heard they're with a competitor and it violates the non-compete, you can't, you know what, let's just see if we lose anybody first, any clients. 2 months later, you find out you lost a client. So then you send a cease and desist letter. Well, I haven't heard of any more damage. So let's just sit back. We're not prone to go have litigation. We know it's expensive. Well, then another 2 months later go by and all of a sudden you lose a whale. Okay. And then you can try to enforce this thing. Good luck. It's not impossible. You may win depending on the judge, but you've made your life much harder for your attorney because it's going to look as if you delayed in taking action. So I won't go into the details, but one of the things you have to show to get an injunction is that you were going to have irreparable harm if you don't get an injunction. Money damages aren't going to be sufficient. You can't get these clients back if he keeps taking them in the lawsuit, he or she. But a judge will say, wait a minute, how can you be irreparably harmed if you sat on your hands for the last 4 or 5 months doing nothing? Seems like you were fine with me with it, knowing they were violating this agreement until you started losing too many clients. Okay, so just be aware of that. And if this is a situation where you're not aware of someone taking any clients, they're just out there competing, sometimes, not always, I'll recommend kind of a middle step between a cease and desist letter and the actual lawsuit, which is sending a second and final cease and desist letter with a copy of the proposed lawsuit. Okay, especially if it's somebody who started their own company or they haven't been involved in litigation before. Merely seeing a copy of a lawsuit, even if it's been filed yet, just has a psychological impact on them. Okay, so sometimes I recommend that, assuming the company is not already bleeding from losing clients. Any questions on enforcement? Because we're going to turn lastly to defending these things.
I have a question as far as, actually I have 2 questions. Because we went back as far as finding things out. What about social media? If we found things that they posted on social media, can we use what they post on social media against them?
Yeah, absolutely. And what I recommend doing is taking screenshots. So as part of our due diligence, we tell the employer to go look for A, B, and C. And on our own, we'll have the paralegal go and look through, and we'll actually, it sounds like it's going, I guess a private investigator type situation, but we'll actually have like a shell account for LinkedIn, so they don't know that we're an attorney looking at them. Okay, and we'll look at their LinkedIn account, look at their Facebook, any of their social media. If it's a new company, the website they put up, and we will screenshot, or has the date and time of the screenshots, everything we find. Okay, because 9 out of 10 times, especially if it's an entrepreneur not with a larger company, once they get sued, they will scramble and make changes to their LinkedIn, to their website, to their social media. And the fact they made that change, you've now manufactured evidence against them. Does that make sense?
Mm-hmm.
Okay. The short answer is yes, I would go do that.
Okay. Okay. And you answered my second question. Thank you.
All right, so now we're on the tail end of this. You're considering hiring someone who's subject to a non-compete or a non-solicit. First off, as y'all know, if anyone who's ever hired people with subject to these agreements before, ignorance is not bliss. You don't want to put your head in the sand. Know upfront if they have these agreements. Actively ask for it. Yes, should they tell you? Sure, but you should also be proactive in asking for it. It's a little, it's a bad business practice, okay, to go and spend the time and money to bring on someone new, to onboard them, to be in the middle of training, and all of a sudden, they're 3 weeks in, starting to get the hang of things, and all of a sudden you get slapped with a nasty gram from the prior employer saying, cease and desist because of this agreement, okay? Let them go, we're gonna sue them and sue you too. Happens all the time. So the way to avoid that is you be proactive and ask for that, okay? I've seen many employers on part of their onboarding process will have them sign documents, confirming, a host of things. One of which is that they either A, don't have a restrictive covenant, or if they do, they have disclosed it and provided a copy to the employer, okay? And by the way, side note, that'll also protect you from potential liability from the prior employer if you didn't learn about it. So what happens if someone does have a restrictive covenant? Questions to ask, what type of employee is it? If this was someone who wasn't in sales and wasn't in management, then that the non-compete provision, non-solicits are likely less enforceable. Okay, they don't have relationships with clients. What secret sauce are they going to have if they're not, in management, or if they were kind of, low level there? Plus, the former employer is much less likely to care. Okay. Second, is it a non-compete provision or just a non-solicit? If you're hiring someone who's just as a non-solicit, not a non-compete, well, maybe that's fine if you have, if you can just direct them to make sure they don't contact any of their prior customers. Okay. And maybe it's still worth bringing on, or maybe you want them contacting their prior customers, and so if they have a non-solicit, you don't want them coming on. Either way, it's good to know. And even if it's a non-solicit, this is getting the weeds, but is it a non-solicit of customers, period, or is it a non-solicit of customers and prospects, period? Big difference. I had a case a few years ago where someone came to me. They started their own company. They knew there was going to be a fight over the agreement. I looked at it and realized, these guys forgot to put in the word prospects. Okay. Whether it was accident or not, it wasn't in there. And this guy had a few whales on the line. So what did he do? He, by design, left. He timed it just right. They weren't clients yet. And 1 month later, they were clients at the new company he had started. He got a nasty gram, then sued, and they eventually dropped the lawsuit and paid some of his fees. They realized everyone it took was a prospect. They just couldn't get around that. Okay. And of course, finally, if you do hire someone with a non-compete or a non-solicit, they could be doing things that would violate either. It doesn't mean you don't have to hire them. Okay, it's not a criminal act. Okay, it just would subject you to potential civil liability from a lawsuit from the prior employer. And perhaps that situation where if the person is a large enough rainmaker, it's perhaps a cost-benefit analysis of what's the revenue they're likely going to bring versus what's the risk and what's the cost of a lawsuit. And those are just conversations to have with your counsel. Okay. All right, last one, strategies for defending. If you're someone who is thinking about leaving or has already left, and maybe you have or haven't got the nasty gram yet, these are things that we always vet for, and that other firms who specialize in this will vet for to help defend them. Okay, so if I get a cease and desist letter, what I'll look for are a couple of things. First, is the agreement itself enforceable? Did they provide a copy of it? Was it signed? Did you change positions? Is there a new employer that perhaps it wasn't assignable because there's no assignment provisions? Things like that. And second, I will vet whether there are any potential employment law violations. Okay, so maybe someone wasn't paid their commissions properly. Side note, people in the staffing agencies get this wrong all the time. If someone's being paid off commissions, generally speaking, they're entitled to their commissions even after they're separated from employment. I'll repeat that, even after they leave. You still got to pay their commissions, absent some exceptions. One being you have a contract saying they're not entitled to it after they leave. Most employers will do that. A lot of them don't know to do that. They didn't do that, and they just assume, hey, this guy or girl is no longer there. I don't owe this to them. They're not an employee anymore. They're wrong. Okay, and there's a few other exceptions that just don't apply in the context of the staffing industry. But in short, if you don't have an employee handbook or a policy or an agreement that they were put on notice that they weren't entitled to their commissions after leaving, they're generally going to be entitled to it. Okay, and so then you'll have, then they'll be countersuing you for their unpaid commissions, and they'll attempt to convince a judge that the non-compete or non-solicit, that agreement is no longer enforceable because there is a prior material breach of the agreement. In other words, your honors, they can't enforce this agreement. They breached it in the first place by not paying me right. Okay, and that's a very common defense. Related to that, another wage issue is misclassification. We've got lawsuits going on right now. We're both defending staffing companies and suing staffing companies. Okay, dealing with misclassification. If you have your sales force, your recruiters classified as exempt from the FLSA, what I mean by that is you pay them a salary or maybe a salary and conditions or maybe a straight commission, and they're not getting any overtime, you need to speak with your counsel. I'm just going to be direct about it. You need to speak with some attorney. Okay, that's unless they're management level or they're out and about field on a regular basis, there's a good chance they're misclassified. Okay, y'all are a hot industry for getting this wrong. Okay. Similarly, if we discussed earlier, someone changing job roles, and then we'll look for any other violations. And the point is, these are the kind of things we look for on the defense side. Also, I always recommend, you respond to the cease and desist letter in detail. If you think you have a strong defense, or if you're just trying to create a strong defense, to make it less likely they're going to come at you in a lawsuit, or you want to put yourself in a better position to settle, you're not going to do that by putting your head in the ground, okay, or head in the sand. Reply in detail, and explain why in detail that you're not violating it, okay, or why it's not enforceable, or both, okay. I won't get into the last part. I left that on there by accident for when I give this seminar to attorneys. There's a lot of strategy involved on enforcing and defending non-competes. They're more like litigation strategy. But if you are in a situation, you're dealing with a situation that is at a current dispute or potential lawsuit or in a lawsuit, feel free to reach out and have a conversation about kind of the nitty gritty on strategy for enforcing and defending these things. So that was a lot we covered. Kind of open floor on questions.
If you guys have any questions, you can either raise your hand or you can go ahead, David. Go ahead and unmute yourself.
Thank you. I appreciate it. Well, so regarding what you were just recently talking about, we have in our offer letter that they sign that it says they don't have any type of non-compete that would conflict with their employment with us. But what I find quite frequently is people get confused, non-compete, non-solicit, confidentiality, non-piracy. They get it all confused and wrap it up under non-compete, which you mentioned earlier. So then I get this conversation going with them. I'm real specific. I say, okay, did you ever sign a document that says you can't work for another company similar to that company? Try to unpack and explain it a little bit. That helps a lot. And they'll say frequently, oh, no, I never signed that. Or they'll say, I don't know, I'll send you my document and you can take a look at it. So at the point of them offering to send it to us, that's probably not a good idea because then we're reviewing a contract.
So first off, the initial conversation you had is prudent. Most employers don't do that. So that's a wise thing. I would recommend you do receive a copy of it. Again, ignorance, not bliss. It does you no good to cover your eyes and, I don't want to see it because if I don't know what you can't do, then I can't be liable for you doing it. Because again, the way it'll play out is if that person if they've got it wrong, okay, and they are doing something that'd be in violation of it, then, once the new employer reaches out and puts you on notice and gives you a copy, then you certainly can't ignore it. And if you continue to employ them, then you can be subject to liability for tortious interference for the contract between your employee and their former employer. And you're like, okay, great. Well, I can avoid that liability by letting them go. Yes, you can. You've avoided liability, but now you've also wasted a lot of resources and time on interviewing and onboarding that person in the first place.
Okay. And can I just ask one really quick question?
Absolutely. Yeah.
What do you think the future of non-compete provisions are? It sounds like from the department, years ago with the Jimmy John situation, it came up, and then I've heard with the Biden administration, that's a concern of theirs as well. And I think it was maybe a concern of the prior administration as well.
I don't have a crystal ball. I don't, know for sure. No one does. As of right now, and there's a, an ebb and flow on these things. Right now the trend is that too many employers are either A, having individuals sign non-competes that have no business signing non-competes, or B, they are trying to enforce overly broad non-competes on employees. And I've seen it firsthand. There are a lot of employers out there who are having their sales force sign agreements that keep them out of the entire state or the entire U.S., even if they're only operating in a few counties, okay? And even crazier, a lot of them are actually acting on enforcing those things under the assumption that this person can't pay to defend themselves. They're going to be forced to capitulate to my attorney because we had the money and they don't, okay? You know what? That's a gamble. if that's the strategy you want to use, I'm not going to condone that or, say that, that's morally bad or good. It's a business practice. Act, how you, govern yourself how you want. But just be aware there are more and more attorneys out there who are willing to, defend somebody in a situation where they feel strongly that the company has overreached just to make a point. Okay. And just to, they'll market it all over LinkedIn. Some of y'all may know folks like this. I'm not going to name names. I encourage you not to either. But they will, like a banner wave around. They're defending employees for these overbroad non-competes. And next thing you know, you're getting bad publicity for it. Okay. I'll also say nationally, yes, more and more states are trending towards enacting laws that either prevent or substantially curtail the use of non-competes. Okay. I would say right now about 1/3 of the states, not 1/2, about 1/3 of the states have laws either outright prevent it for employees. And to be clear, it's non-competes, not non-solicits. Okay, I know of no state that has prevented non-solicits, even California. Okay, we're talking about non-competes here. So states are trending towards cutting back on the use of non-competes. Obviously, whether it is Republican or Democrats who are in charge of the state or Congress or the president is going to make a difference on the state and national level. But like all things, I doubt it's going to, I don't foresee it being 10 years from now, nationally, non-competes aren't allowed at all for employees. I think this is going to be more of a state by state type thing. If it's done on a national level, again, there may be some, chipping away at it, but I don't see it's going to be outright throwing out non-competes. Any more questions? All right, well, if anyone else has any more questions, either now or otherwise, feel free to, I know a lot of folks have issues that come up that for whatever reason they don't want to discuss, kind of publicly, in a seminar like this. And so I regularly get calls afterwards, and feel free to reach out we'll set up a time to talk and see what's going on and answer your questions.
Yeah, just so you guys know, if you guys are a member of the Florida Staffing Association, you can log into your account and review this. It does take us a couple of days to get it up. In addition to that, we will be sending out information to you in regards to giving you Will's contact information so you can reach out to him directly, as well as part of the presentation. So I just want to personally say thank you everybody for joining us today. We are continuing to hold webinars throughout the remainder of the year. So please be sure to check out our website for the upcoming webinars that we have scheduled. And a special thank you to Will for being here and being supportive of the Florida Staffing Association. And we look forward to seeing you guys next time.
Thank you, everyone.
Thank you, guys. Have a great day.